do nothing about the advocacy around many of the mental health issues in the overall protest. She helped me understand what advocacy is from a defense counsel's perspective. She's passionate about her work. She's opinionated. Respectfully, Your Honor. And I know that tomorrow I may have to appear in court for another matter, so I will stop there. But I will say, Justice Perkins McFay is a very strong advocate of the HSJCC. She's been a member for years at a local level, a regional level, and sits on provincial tables, giving her expert opinion from a perspective of advocacy and supporting the community. She continually reminds us at many meetings there is either a young person in the middle of this discussion or a person in need in the middle of this discussion. And from there on, she processes it, of course, like every other judge does. Please join me in welcoming Justice Perkins.
He promised me he wouldn't embarrass me too much. Maybe I wish he'd stuck to the bio. It's a lot to live up to. First of all, I do have to preface my remarks by saying these are not the words of the Ontario Court of Justice. I'm not here in any policy-making capacity. These are my thoughts and my thoughts alone. I want to thank you for inviting me because it required me to address what I call my crisis of faith. That's why I'm here. I asked and I asked, what am I going to talk about? No one sent me an email or reply. So I decided I would look at the themes of the conference, I'd look at the program, and speak from the heart. So, you've heard John Bradford. He talked about personal resilience. I'm here to talk about the need to change our mental health courts and the approach that we're taking. To many people, to hear me criticize mental health courts is heresy. I'm going to be truthful. I had a Crown attorney email me begging me not to talk about this. So of course, here I am. These are issues that matter to me, and that's why I'm here. Mental health courts matter to me. Raise your hand if they matter to you. Good. We're all on the same page. And my crisis of faith is, are we doing the right thing? What are the programs that work? What are the models that work? Why do we do what we do? I'm tired of paying lip service to the fact that mental health courts are fantastic, the treatment model we have works, and it all in the end is going to work to reduce recidivism and increase public safety. How many people in their terms of reference of their mental health court have those words? Maybe you guys don't have terms of reference, but I can tell you the court programs that I looked at all suggested that that's what they were going to address. So really, as the topic suggests, I'm going to talk about institutional resilience in part as a way of addressing how we can change what we do and make it responsive to what the evidence says works. The definition of institutional resilience is the capacity to recover quickly from difficulties. So for an institution, it means the ability to build and increase the capacity for learning and adaptation. I didn't make up the term institutional resilience, by the way. There is a very scientific sustainability model that I could bore you to death with for about 3 hours, but I'm not going to do that. What I really mean to say is that institutions matter. We do have to have frameworks. The institutions that we have affect individual actions. They influence how we cooperate with one another. And these institutions can be crucial in making the difference to those things that matter to us, which is justice, liberty, and fairness. The danger lies when institutions become stagnant. So, what do we do when the emerging evidence rather, challenges our practices and our policies? Mental health courts, as we know, have sprung up across the country and across the province. But how successful are they? Does anybody know? We all feel they do a good thing, right? But did they really? Is the criminal justice system really equipped to deal with it? Minister Naqvi suggested saying that we're trying to be many things. The system was not designed to be. So mental health courts, like other innovations in justice, began, quite frankly, as an experiment. Testing a proposition that linking mentally disordered accused to court-supervised, community-based treatment would lead to improved mental health outcomes, reduced recidivism, and increased public safety. I took that basically from the Ottawa Youth Mental Health Court and Adult Court Terms of Reference. And I have repeated that phrase endlessly since that court began in 2007. But are these goals being achieved? So, my crisis of faith was that I didn't want to pay lip service to it anymore. I was tired of simply repeating the words with a big smile and hoping people would believe me. And I questioned increasingly whether the mental health court model that is used in Ottawa and in many places across the province really works. So, being the last speaker today in a very warm room, I can see the fans going, is difficult. And don't take everything I say as gospel. I've done my research. I've looked at studies that have been done across the United States and Australia. I've done some thinking about this, and I don't speak about it lightly. I simply want, in this last session of this fantastic conference, that all of us take off our rose-colored glasses, that we take the opportunity to pause and reflect and think, examine where we've been in the past, which was not good, what we're doing now with our mental health courts, and more importantly, I want to start a dialogue about where we can go in the future. And it has to be consistent with what I think is the emerging evidence. I'm going to share with you a little bit of how this crisis of faith started. I was driving to St. Lawrence Valley Treatment Center to address a group of judges to explain to them what this facility can bring and the importance of how judges deal with offenders in the mentally disordered offenders in the justice system. As I was driving, I thought, isn't it fantastic? We've got this facility for male, unfortunately, mentally disordered offenders where they can receive specialized psychiatric treatment at the same time as they serve their sentence. And then as quickly as I had that thought, I thought, isn't it awful that we have to build a whole jail, that there's a waiting list for these persons? What are we doing wrong? Why is it I keep seeing the same John Doe in my court, month after month? Something isn't right. So, that's what began my crisis of faith. So, I questioned, what are we doing and what works? What I really, really want to know is what works. How many else of you have wondered that? a fair percentage. Because I'm now the local administrative judge. I have to look at where we put our resources. You all in your organizations have to do that when you do your budget implementations. When I'm giving resources to an institution, I want to make sure it's going to work so that we can really make a difference to our mentally disordered offenders. I'm also concerned that we've become a victim of our own success. The criminal justice system has moved to a position from a position of last alternative to a position of first point of entry for persons with mental health issues. It often provides the only available option. Far too many times, families exasperated knock on the door of the criminal justice system because they think it's the way to get access to treatment through the mental health court, through the mental health court worker. There are huge problems for having a mentally disordered offender enter into the criminal justice system. That shouldn't be done lightly. The criminal justice system really wasn't designed to be the avenue of social justice. That's what it's become. Many of my colleagues complain. They say, I'm not a social worker. You go into that court. You're into that kind of stuff. I'm there to determine John Doe committed X crime, what's the fit and appropriate sentence, and how many days in jail. So that's the problem. Is the criminal justice system really the vehicle that we need? We all know that the closure of institutions have led so many mentally disordered and persons with dual diagnosis and cognitive impairment to come before the courts. We know that the criminal justice community recognized that, and that's what they thought mental health courts would solve. All right. Forward would be better than backward. As you know, in Ontario, since the Toronto Mental Health Court opened its doors in May of 1998, there have been more than 38 mental health courts that have been created. I included in that number those courts that call themselves community courts. There are now 11 drug treatment courts. I'm told, as a result of a survey that was conducted by our Chief Justice's office, that there are 52 service vehicles across the province that offer diversion and court support for persons with mental illness. There are some jurisdictions that are just finding out about mental health courts. I get calls on a regular basis. People saying, wouldn't it be fantastic if our region could have a mental health court? They were, of course, considered pretty revolutionary back in 1998. And there was lots of pats on the back and people saying, isn't it fantastic that we're doing this? Mental health courts were created largely as a result of a number of motherhood beliefs, as I call them. So, I know you've been sitting for 3 days. It's time to engage. Raise your hand if you believe that untreated or inadequately treated mental illness contributes to criminal behavior. Raise them a little higher. I want to be able to see. All right, I wanted to have clickers so that I could actually do like a graph, but it was too expensive, so we just got the show of hands. Most people believe that. Second of all, criminal justice involvement can serve as an opportunity to connect people to treatment. Raise your hand. All right, fewer, but still, I would say more than 65%. So we think, well, I'll get there. I'll get there. Just wait. 3, appropriate treatment can improve the symptoms of mental illness and reduce problematic behavior that led to police involvement. Raise your hands. Oh, I think pretty unanimous. And 4th, that by doing all of the above, we'll see a reduction in recidivism and improved public safety. All right, I'd say maybe 30%. Strangely, these fundamental principles that form the framework, basically, of our mental health court structures preceded any significant research or testing. Anything that really tested the underlying logic of these beliefs, these core motherhood values that we talk about. The other problem, and I think it's something you've probably heard before, and if you were at this conference a few years ago when I spoke, you'll know that it's one of my issues also. There are so many mental health courts across Ontario. They are all different. There are few commonalities. We have never developed anything that's local that suggests what is best practices, what should be the core elements to a mental health court or a mental health court strategy. All of the courts differ. I mean, they generally have at their core a concept of therapeutic jurisprudence, but some courts are diversion courts that only deal with low-level offenses. Some people use more of a drug treatment court model. Some merge the two courts together. Some require a plea of guilt. Some don't take people with serious facing a serious criminal offense. And some don't take people who have lengthy criminal records. There's very few commonalities. In Ottawa, our court is a mishmash of all of the above, and I'm speaking of the adult court this time. And I'm going to tell you, up until I had my crisis of faith, I was patting myself on the back on a regular basis about the Ottawa court. And I still do. So I still think we do good work and there's a place for it. I just want to look at what we can do better. Our Ottawa Mental Health Court, I thought we were evolving. I didn't think we were stagnant. We have a clinic. The doctor attends, he does the triage, we can provide immediate access of persons to a psychiatrist. I thought that was fantastic. A change in procedure now means we have to have a referral through a family doctor. It's going to cause a huge gap. It's going to cause delays. In addition to that, I looked at the fact that I had judges complaining to me about our mental health court. They said, it's like being in a remand court. Nothing goes on. Don't even need me to be there. They could be adjourned by a justice of the peace. And I thought, the studies that I've read suggest that the role of the judge is important. If it's just a remand court, maybe we need to do more. We do have dedicated Crown attorneys. We have dedicated staff. We have wonderful service providers such as the CMHA, John Howard Society, Salvation Army, and many more that attend on a regular basis, and they are the core of the court. They're the ones that are doing all that hard work in the background. But is that the model that works? So this is my questioning. This is my opportunity to espouse my crisis of faith. And I've been involved in the court since its inception. I was one of those fortunate defense counsel that pushed for it, that asked for it, and I've been involved ever since, and I'm not giving up, just so you know. I have been pleased at some of the innovations that we've done. We've now started to use video to avoid people being needlessly transported. The police are thrilled at saving thousands and thousands of dollars. Accused are happy because they're not being stuck in the cells, they're not having to be transported. So I was thinking, gee, we're a really cool court, we're into the modern day, we're using video, it's less stressful for the accused. And I thought, is that enough or is that window dressing? I decided it's window dressing. It's fantastic, but what we need to examine is what's at the core. So, I started to wonder, what's the best model? What does the evidence say is the best model for a mental health court? What are the key elements or frameworks that each court should have? What's the key to improving access to service? mobilizing our community partners. I know I sound like an ad for the conference. And how do we reduce recidivism? How do we really improve public safety? Then I said, does the answer really lie with mental health courts at all? Or should we just better coordinate existing community-based services? So, I started to look in Canada. What do they say about our Canadian courts? I didn't find very much. I found some very small studies, most of which were buried. One about the Toronto Mental Health Court was very brief, it's not comparative, didn't attempt to address these issues. So, the only one I could find in Canada that was thorough and comprehensive was the very thorough evaluation done of the Youth Mental Health Court at 311 Jarvis, which was, of course, released in March of 2014 by Krista Davis, Tracy Skilling, and Michelle Patterson-Vidali. If you haven't read it, you should. It's called A Process Evaluation of the Community Youth Court. So it's fair to say that one of the problems we have is we have no Canadian evidence. Our courts have not been evaluated. Why not? Are people afraid? People have asked, and it always stops. If we're afraid to be evaluated, then we have much bigger problems in my view. Fortunately, there is a significant body of research into mental health court outcomes from the United States and Australia. These studies aim to evaluate whether their courts were effective in reducing recidivism, psychological and legal stress on the accused, and of course the severity of any new arrests and the gap in time between committing new offenses. Their courts also vary in structure. I think it's fair to say that very few courts are similar in nature. They're as unique as some of the individuals we all deal with. But there were some common elements that allowed for some comparative analysis, which I admit are not features of many of the courts across Ontario. The court models that were studied all had regular pre-court meetings with the judge in attendance that involved the entire treatment team sitting down and discussing each individual. Very similar to what goes on in drug treatment court. All of them have dedicated judges or groups of judges, as well as dedicated court staff and prosecutors. Quite frankly, their treatment regimes were very structured, and so structured that they had easy and measurable outcomes to success. Many of the U.S. courts that were profiled required a guilty plea. That guilty plea was often vacated if somebody successfully graduated from the program. Almost all of the courts used various forms of incentives to promote participation. As I said, from dismissal of the charges, praise from the judge. Some had gift cards. Like in our drug treatment court, we give out $5 Tim Horton gift cards. All of them set a minimum time period for participation in the court, and it was set out at the outset. Our court in Ottawa doesn't do so. We don't have a structured or regimented a treatment program. And a multidisciplinary team that was defined was also a common feature of the courts that were profiled. So the common elements of the courts that the U.S. studies proved were shown to reduce recidivism were status hearings, voluntary court docket, access to mental health services designed to reduce offending and improve general health and functioning, and a multidisciplinary team. One study supports the theory that structured mental health courts with regular status hearings and interactions with the judge was more likely to reduce recidivism than mental health courts without these factors. I didn't think judges made a difference. I think they're wrong. the author of this study compared the recidivism rates between a group of persons with mental illness who went through a regular court proceeding against a group who participated in the mental health court. So everybody had a mental illness, some participated in the mental health court, some were in a regular court process, and even those in the regular court process were still supervised and were still given access to services while on pretrial release by what they called a specialized supervision unit. So they were getting the Cadillac treatment. So everybody's got access to treatment. The difference is some people were in mental health court, some people weren't. And the difference was those in mental health court were monitored for compliance. Their compliance was measured, and there were sanctions, positive and negative, if they didn't comply. The participants were required to show substantial compliance between 4 and 6 months in order to graduate and have their charges withdrawn. Now, I do note that the courts that were involved in this study only dealt with summary conviction offenses. Graduates from the mental health court had fewer arrests and a longer time to re-arrest than the non-completers of the specialized supervision control group. So, what does that say? The study supports the theory generally that structured mental health courts are more likely to reduce recidivism of mentally disordered offenders than those who are not involved in this very structured setting with the regular status hearings before the judge. So at least on the surface, and I'm only at the surface point here, guys, the research studies appear to validate the assumptions underlying structured mental health courts. There was another study that also strongly endorsed the significance of a structured mental health court. It's by a person named Mr. Bradley Ray, who's a regular contributor to the research on mental health courts. He did the longest examination of any courts, and that was the mental health court in North Carolina. This study followed mental health court persons, defendants, for a minimum of 5 years and for up to 10 years to examine their recidivism after they exited the criminal justice system. That court had all of those hallmarks I spoke about in terms of compliance audits. The study found that defendants who completed mental health court were significantly less likely to be arrested. 39.6% versus 74.8%. That's huge. In addition, those persons went longer before reoffending. 17.5 versus 12.27 after having their matter disposed of. This was measured from the time they were actually released from custody. The other interesting fact is that more than half of the non-completers of mental health court who did reoffend did so in the first 3 months, whereas the completers had still not, or more than half of the completers had still not reoffended by the end of the 5-year follow-up. That's fantastic. So, Mr. Ray noted there were limitations to his study, and he really indicated he thought the difference was in the structure of the court, and that made the difference in the recidivism statistics. In fact, Mr. Ray noted that without having judicial supervision, individualized treatment plans, regular hearings for compliance, incentives, and sanctions, that there would not have been the same positive legal outcomes. As I said, there are also these studies that talk about the importance of the judge in dealing with the mentally disordered accused and the real effect it can have on recidivism, and supports the fact that maybe resources are well spent having a dedicated judge that always deals with the same persons. Specifically, there are 3 aspects, apparently, to the judge's role in a structured mental health court that appear to make a difference.
supposed to provide a quality of interpersonal treatment that accords with the person's dignity, respect, voice, and builds trust. Sounds like a pretty motherhood statement to me. I can tell you, I sit in the drug treatment court, and it does make a difference. When I ask somebody how their week went, so I didn't use drugs. I said, I wasn't really interested in that. What did you do in the evenings? What's your critical time when you're at risk of relapse? What did you do to avoid it this week? One fellow said, well, I take my dog out for a walk. I said, what's your dog's name? What kind of dog is it? And he said, you want to know my dog's name? I said, yeah. I'd like to know about you. I'd like to know who you are as a person. You're not just an addict, you're a person, and I want to get to know you. And I know from speaking with persons who graduate from drug treatment court that being treated as a person, not just somebody who's mentally ill or somebody who's an addict, makes a difference. I can tell you when I was asked to sit in drug treatment court, I turned them down. I turned them down for a reason. At the time that I was asked to sit in drug treatment court, they didn't address mental illness of persons with addictions. They only focused on the addiction component. And I said, tell you what, I'll give it a 90-day trial. Give me 90 days to convince those service providers to provide mental health supports and treatment for people in drug treatment court. Give me 90 days to advocate for that, and I'll give it a try. Well, now it's been 7 years. And we do address mental illness in our drug treatment court. And our graduation rate is close to 70%. And I'm really proud of that it's a very, very structured model, and it engages a huge number of resources. Sadly, resources that have been cut with recent budget realignments. The other thing is judges hold participants and service providers alike accountable for their roles. I think that is an important role. And thirdly, a judge provides transparency and explains the reasons for their decisions. The study basically said that a successful judge treats participants as well as service providers politely, with respect for their rights and interests, by asking them about their concerns. The judge is supposed to emphasize problem solving over blame, about giving people second chances, making allowances when they fall back into their own ways. The study didn't stop there, or I didn't stop there with the study, I should really admit. I was sitting at home one day on a non-presiding day, and I thought, wouldn't it be good to talk to some of these judges? So when my husband looks at the telephone bill and he sees California, Brooklyn, Washington, I'll have to explain. I spoke to a Matthew Demick of the Brooklyn Mental Health Court. They've got a fantastic program called Stop the Madness that I was really impressed with, so I gave him a call. And I said, what do you do as a judge in that court? How do you make a difference? What is it? I want the answers. And he said, really, I believe engagement is one of the reasons for our participants' success. He said, and this really stuck with me, it's the same as every other relationship. If I engage with somebody and that person engages with me, we don't want to disappoint one another. We want to be there for one another. He said that people who are dealt with in that way feel that the legal system and their treatment is fair, and it internalizes the values of the court and the values of moving forward, and it shows and allows for greater compliance with court orders. So, caused me to think. Caused me to go back to that 311 Jarvis study. And that study also confirmed the importance of the positive relationships the judge can play. In that evaluation, parents and youth specifically highlighted the fact that the judge could make a difference. One youth said, they look at you and who you are, not just what you did. And one parent said, someone finally cared about us as people and recognize the time and the effort my son puts out. That doesn't sound like your usual traditional justice system, does it? The judge said, I believe in you. You can do it. Keep at it. The 311 Jarvis Court is interesting in as much as they have a single judge that staffs the court approximately 40% of the court days. The remaining is staffed by a pool of 5 judges. All the other team members, the Crown, the Youth Mental Health Worker, Duty Council, they're specifically dedicated. Their court model requires case monitoring, and the Youth Mental Health Court Worker does provide regular updates to the Crown and Duty Council. Outcomes in that court were based on whether the youth made significant progress in treatment and the nature of the charge. Their statistics show 85% had their charges withdrawn, 2.88% received a discharge, 2.88 had the charges stayed, and 8.65 received probation. I do not have any data that shows the types of charges that were dealt with. My understanding is they only deal with the lower level offenses and not with level 2 offenses. So, in my view, research is crucial. Crucial in allowing us to have a better understanding of what works to bring about those goals I think we all share, and how we can better utilize and allocate scarce resources that we have. So, what kind of questions should the court team be asking in trying to design a court that works? And for whom is mental health court effective? Is it only for those low-level people that can be diverted? And under what circumstances should people be in mental health court? And if we are going to have people in mental health court, what programs make a difference? So, here's the part where I start to try to answer my own quest. What works? Intriguingly, the interesting answers have come from the studies that have not asked only are mental health courts effective, but for whom and under what circumstances. Across multiple mental health courts, the factors that were most predictive of rearrest were a higher number of prior arrests, a greater number of days spent in jail prior to entering mental health court, having a concurrent disorder, and younger age. Who agrees that those are the same factors that would address factors towards recidivism regardless of your mental illness? I agree. Interestingly, the seriousness of the charges, or the most serious prior offense or criminal record, was not associated with higher rates of reoffending. Is that a surprise? One court showed no significant difference between violent and non-violent offenders on any recidivism outcome. 2 courts showed, in fact, lower rearrest rates among participants charged with violent and indictable offenses than those charged with property crimes or minor drug offenses. In my view, these results challenge common eligibility criteria that often excludes people who are charged with violent offenses. Many jurisdictions fear that people who are charged with violent crimes that may have mental illness will pose an unacceptable safety risk. And in fact, in the United States, there are a number of U.S. programs that they actually fund their mental health courts. A number of U.S. programs that fund mental health courts that explicitly prohibit funding for programs that handle violent offenses. Most, if not all, of the Ontario mental health courts also preclude acceptance of accused charged with serious violent offenses. interestingly still are the results related to mental illness and treatment engagement. How many of you believe that if you engage in treatment, the criminality will go away? Just like magic. A 2011 multi-court study by Jay Stedman called The Impact on Mental Health Courts on Arrest and Jail Days found only a few links between clinical factors and criminal justice outcomes. People who were in treatment 6 months before going into mental health court had lower rearrest days than those not so engaged. They found that people who had bipolar disorder had fewer days incarceration than those with schizophrenia and major depression. So now I want to do a bit of my own experiment because I don't have the resources that many of these persons did. So, watch it. I know you're hot, you've been here all day, you're really wanting to get shopping at the Eaton Center. So, I'm going to want you to stand up if you think one of these factors is going to make a difference towards recidivism or incarceration. Stand up. History of psychiatric hospitalization. Is that going to make a difference towards recidivism or incarceration? Nope, no one's standing. Symptom severity at the time of enrollment in mental health court. Still no one standing. Insight into mental illness. Okay? No, keep standing, keep standing. This is good for your health. No, that's it. How about the type of treatment and self-reported treatment engagement? Okay? All right, that's what I expected. And what about adherence to medication? All right. So, the results of my unscientific standing survey, we'll call it, are that this is what you believe. And the answer is none. None of the above factors affected rates of recidivism or incarceration. This is how they summed it up, as I said bluntly. We found no relationship between the type of treatment intervention received or not, and whether the mental health court enrollees were arrested or in jail following mental health court enrollment. That affectation is entirely mine. So, these findings certainly strike a blow to the logic, which led to the creation of many mental health courts across the province. And further, when I look at those 4 clinical characteristics considered, I realize that the Crown attorneys in our jurisdiction are making decisions about how successful somebody has been in court using those factors. They're staying or withdrawing charges because somebody has now gone to see a doctor and they're on their meds. They're making those decisions, in my view, perhaps, thinking that it's going to increase public safety and reduce recidivism and all is going to be well. And now we learn that indeed these are not predictors of rearrest or incarceration. So why do we continue to use this marker? What does it mean? Does it mean treatment is irrelevant? No, it doesn't. It doesn't mean that. Clearly, there are measurable benefits to individuals from treatment engagement, other than recidivism or public safety. And those are important, surely. I'm not downplaying that in any way, shape, or form. And longer periods of wellness are positive measures of outcome. The real question is, what does the research mean? The research shows that a greater like to treatment allows individuals to better be able to engage in other programs that may really affect their success. study in a nutshell, because those of you may be starting to get bored at this moment, basically says this: treatment's great, but it only goes so far. Treatment is like taking one step, and I think all of us want to be off the stage. Treatment allows individuals to maintain the stable housing, perhaps not be involved in causing disturbance on the street in the middle of the night. Having treatment allows people to engage in educational and vocational training, maybe leisure activities, all things which make a difference. So how do we do this? How do we make all these things available fully and truly to our mental health court participants? And what explains the good results? Essentially, one of the studies said that unintentionally, some mental health courts are able to provide some measure of supports in these areas, and that's why we see the very positive results. So, essentially, all of you are much better versed than I am on the risk needs responsibility model. But that's essentially what we've started to go back to and what these US studies have gone back to. They say we need to look at who we are going to target, and we should allocate our scarce criminal justice resources accordingly. They say we should really be targeting those at the highest risk of reoffending. There, of course, has been substantial research which have identified the 8 central risk factors most predictive of general criminal behavior: antisocial history, personality pattern, substance abuse, family discord, lack of success in education and employment, lack of engagement in positive leisure activities, negative peers and friends, attitudes. You guys know this. But that's some of the framework the U.S. courts have started to utilize. They're also looking at the need principle, what to target. And they suggested that high-risk offenders should receive the treatment that targets their particular criminogenic needs. And addressing more of those individuals' criminogenic needs will bring greater reduction in recidivism. And lastly, responsibility principle, how to address those needs. So contrary to the assumptions underlying the development of mental health courts, mental illness is not a risk factor to criminal conduct. Many people don't believe that, but that's what all of the studies show. Relatively few crimes are committed actually when someone's in an active psychotic or manic state. And when they are, we have a system for that. The forensic mental health system, we have Part 20 of the Criminal Code, takes care of it nicely. From an R&R perspective, which recognizes the prevalence of criminogenic risk factors among justice-involved people with mental illness, it appears that they're the same. Those with mental illness and those without. It still plays a role in the R&R framework, but as a responsivity factor that affects their ability to participate in and learn from the interventions that you people assist. I spoke to Judge Stephanie Rhodes of the Alaska Mental Health Court, and she said, we used to believe mental illness basically was the direct cause of criminal justice involvement. She said it turns out it's very few people for whom that's true. So while treatment for mental illness remains crucial for mental health court participants, it's not because improvements in symptoms or functioning will have a direct impact on their criminal behavior. It's because treatment will enable them to better respond to the programs that will address their criminogenic risk factors. So the R&R framework suggests a number of new possible guidelines for mental health courts. And that is, courts should set their eligibility criteria to focus on accused at highest risk of reoffending, not the lowest rung. Those persons can be diverted without all those resources. Second of all, courts need to incorporate programs to address criminogenic needs in an array of services. The vocation, the education, all the types of things that in a very structured drug treatment program, a person must succeed at before they graduate. Hence the reason for the high graduation rates and the high sustainability of that wellness. Thirdly, courts need to address the accused individual responsivity factors to facilitate engagement in those criminogenic needs. Address housing, address employment, make sure they have a life. It's not all about illness, it's about wellness. Make sure they have friends and they have contacts in the world and the community. The mental health court programs in the United States have had the highest success rates, typically required treatment, education, vocation, employment, and substance abuse treatment where applicable. Raise your hand if your structured mental health court requires all of those things in order to graduate and have your charges stayed or withdrawn. Not a hand in the room. Ours doesn't either. Oh, sorry. And where are you from? Excellent. I'd be very interested to know more about your court and how structured it is. In Ottawa, the focus remains treatment, and to a lesser extent, wanting to ensure safe housing, but it's not on a long-term sustainable basis. There's no structured program that says how long somebody has to be in the program or what their measures of success may be. In the United States, the mental health court policy and services have changed as a result of these studies and evaluations. They've moved away from a medical orientation that emphasizes meds and biochemical approach to something that really emphasizes the importance of addressing all aspects of their lives. So where do we go from here? The policies suggest that we need to change what we do and target those criminogenic factors. So, interestingly, we come full circle, and the conclusions of the comprehensive evaluation of the 311 Jarvis program is entirely consistent with these U.S. studies. I'm going to quote from their evaluation. It says, perhaps one of the most important findings was that approximately half of our youth did not receive treatment matched to their mental health needs. And another half of youth did not have the areas of criminogenic need addressed through treatment. In keeping with the empirical evidence for treating justice-involved youth with mental health needs, it will be important for the court to consider how it can address both the mental health and criminogenic needs of its clients moving forward. So it comes back to this. We've got to change what we do, in my very humble opinion. I also think we need to move away from mental health courts being the place of first access. Mental health courts have a place in our justice system and have a place in the treatment of those that must come to those courts. And I think it is not impossible. I think it's a very attainable goal to change how we do mental health court in Ontario and model it in our own fashion based on some of these studies. We have so many fantastic social justice partners and stakeholders in our communities. And by better mobilization and engagement of those, and moving away from all those silos, some of what Mr. Nacri was talking about earlier, I think we can do that. The other thing I think we really have to think about, and this is something that's a grave concern to me, is the costs of having any mentally disordered offender enter the criminal justice system is huge. We may think on a paternalistic level that we're doing them a good thing giving them access to treatment. They can be in mental health court. But the studies suggest, and John Howard they released their program not long ago, suggesting that once persons with mental illness are charged, they're more likely to be held in detention and denied bail. Once they're released, they're more likely to breach conditions, and so the turnstile begins. Those breach of keep the peace provisions that keep people in custody. The John Howard Society study found that of those on bail, 40% had mental health issues, 31% had concurrent mental health and addictions, and sadly, the numerous bail conditions that have been imposed set them up to fail. Not supportive. And their quote from their report was, "Our justice system is in a sense policing mental health and addiction." The other thing that's a huge problem is when people who have mental illness are in custody for any length of time, they lose their housing. It may be a bed sit, as the Brits call it, but it's their housing. And I constantly have people making submissions to me. "Your Honor, if you can just let me out today. I've only been in 28 days, and if I get out by the time the 30 days are up, I'll still be able to keep my apartment." That's when I usually suggest the Crown and Defense come up with a plan, and I'll bring them back in front of me so that I'm seized, and I can begin my own informal mental health court to see how they're doing, because I'm going to engage with them, I'm going to support them. The other thing is, we know that persons with mental illness and developmental disabilities often self-medicate. We don't identify those problems early enough. They end up charged with drug offenses, mandatory minimums, back before the court. We really need to look at early identification of some of the problems. We don't want to stigmatize the persons that come before us, we want to support them. So, as I've said, the conclusions of the 311 Jarvis, going forward it'd be much better. So we want to prevent, and I think that's the other aspect of what we need to consider. We want to think carefully before we put people with mental health issues into the criminal justice system. We want to avoid being the victim of our own success and become involved in net widening. We need to increase the number of supportive housing programs. I know that that's been a theme throughout this conference. We all know that housing plays a significant role, and stable housing goes a long way in ensuring wellness on a long-term basis. In Ottawa, we have a number of Housing First initiatives, including the ICM OASIS program, and that's been very helpful. But it's not linked to our court. I try to link people to the program, but it's not linked to our court. Second of all, we need to be involved in creating proactive and accessible mental health care. I borrowed your logo, Gord, hope you don't mind. And that's because YSB has been involved in a number of programs that recognize that. I also want to say that we need to, I know that we engage, and I know we talk about that word mobilization, but we really need to move on this so that we can recognize all of the talents that our community justice organizations have, because they're fundamental partners in dealing with mental health issues. Because I didn't want to end on like a negative note, my husband said, "You sound like Negative Nelly." I said, "No, you're right. I don't want to be negative because I'm here because I don't want to pay lip service. I'm here because I'm passionate about it." And there are a lot of great things going on. So I thought I'd highlight the fact in Ottawa we have the John Howard Gardner Street program. It's an example of the kind of collaboration, bringing forth housing and supports for persons with mental health and addictions, persons who've been, this is sort of their last chance in the criminal justice system. Wouldn't it be great to be able to partner with a program such as that? I mentioned Youth Services Bureau. Okay, Gord calls it the SHED program. I'm sure that there is a fancy title. A Effectively, what that building stands for is a place for youth to learn to make furniture, to build planters, to build houses, job skills that you could utilize when you're released from custody or in the community. That program is evolving. There's a lot of community supports, and that's the kind of example of the kind of vocational programs that we could engage with in our mental health court system. In addition, I know you've all heard about the Intersections program. That's a pre-charge type of program. An example of ways to avoid people being caught up in the net of the criminal justice system. Give them access before they're charged. Have the police come to the door. Make those recommendations and referrals to those community-based programs. That's another example of a good partner. It's part of a comprehensive mental health court program, in my view. So, before we open any more courts, and before we invest any more resources, let's look at what that research says. I look around this room, and there are a lot of very important people. We're all leaders in the field. And in my view, our communities are measured by how we treat our most vulnerable citizens. And I want to ensure that when I pat myself on the back, or I pat you on the back, that it's because we're doing the right thing. We're not just paying lip service to it. I asked my very able assistant to find some images that she thought would be appropriate. I gave her full rein, and she came up with these fantastic images, which in my view sums up very nicely what I've had to say today. Thank you for listening to me as the last speaker in a very heated room. I've enjoyed having the opportunity to be part of this fantastic conference, and I hope to engage with all of you moving forward and finding a way to find what works in Ontario.
Thank you, Justice Perkins McFay. Again, you left us thinking. We will go home thinking. We will rethink. And